Abhishek, can you please provide me the screen sharing rights?
Yes, sir. Sure. Arav, can you please do that?
Yeah. Good evening, everyone. Welcome to the orientation session of the second edition of Nyaya Shastram Senior Advocate Ratan K. Singh National Negotiation Competition 2021. I'm Arav, Head Inbound Coordination, and I'll be your host for today's session. To brief the participants about the intricacies involved in the art of negotiation, we have with us our advisory board member, Mr. Akash Gupta, sir. I request Mr. Abhishek Bhushan Singh, founder and managing director, Nyaya Shastram, to introduce sir to the audience. Over to you, Abhishek.
Thank you, Arav. So we have an eminent personality today with us for this session today. Akash sir is working as a lecturer in Jindal Global Law School, where he teaches alternative dispute resolution courses. Also, he serves as the assistant editor for Indian Review of International Arbitration (MNLU), peer review board for Indian Arbitration Law Review (NLIU), and faculty advisor for Mapping ADR blog run by Jindal Global Law School students. In spring 2020, Akash co-headed the organizing committee for 24th annual Sets on International Environmental Moot Court Competition 2020, Indian International Rounds for 10th Indian William C. With Pre-Moot 2020 organized by Jindal Global Law School. In addition to academia, Akash sir has been appointed as a sole arbitrator in 10 disputes and sole conciliator in 250 disputes. He completed LLM in International Commercial Arbitration Law from Stockholm University. During the LLM program, he participated in Wismut and emerged as the top 16 out of 372 teams from all over the world and received honorable mention from the Best Memorandum for Claimant. He graduated from Tamil Nadu National Law University, Tiruchirappalli in 2018. During BLLB honors program, he represented the university at national and international meets. He was awarded the Colin J. Wall Spirit of the Moot Award at 13th William C. Wistis International Commercial Arbitration Moot in Hong Kong. Out of approximately 100 students, he was awarded the first Ram Jethmalani Academic Excellence Awards 2018 for students in the moot category. Akash sir's research interests are in international commercial arbitration, Indian arbitration negotiations, and mediation. Thank you, sir. We welcome you for the session.
Thank you, Abhishek. Thank you very much for your kind introduction and your invitation to deliver this session on negotiations. So before we start, let me share my screen. Okay, so in this session, we'll be discussing about the fundamentals of negotiation from the perspective of a negotiation competition. We'll be looking at the basics. So before we start, let's look into what exactly negotiation is. So negotiation is an interactive process where parties seek to find common ground on issues of mutual interest, where they seek to arrive at a mutual acceptable agreement that will be honored by all. One of the important things which you need to keep in mind that a consent plays a very important role in negotiation. To initiate negotiation, there needs to be a consent, and the parties during the time of discussion, they have all their rights to leave the table. Therefore, consent plays a very important role throughout the process, because unless until both the parties consent to the process, there'll be no outcome and there'll be no result of getting into a negotiation. So that's about the first part. And when we talk about negotiations, it's not like it's just the negotiation competition, or when you talk about the transactional cases, or when you talk about contractual negotiations, it only works in that. Negotiation works in our day-to-day life, and all of us negotiate at some point of time. So we already know how we do it, but there are different ways of doing it. There are better ways of doing it, and there are certain do's and don'ts of negotiation which we need to keep in mind. And a key element of negotiating is learning to make compromises in achieving mutual benefit. So whenever you enter a negotiation room, whenever you are going for a negotiation competition, you need to keep in mind that you can't have everything, but maybe in certain cases you may have everything, but at some point of time you have to give up on something so that you have the bigger interest which is met. So you need to keep in mind that it's all about compromise, and it's all about getting the maximum out of the negotiation. Okay, so let's go to the next part, the basics of negotiation. So we all know that there are two parties, a client and a counsel. And in a lot of competitions, this is the rule that there should be two members, including this competition, and there needs to be one person role playing for the counsel. The other person should role play for the client. So the client, and there is this, most frequent mistakes done by the law students when we judge the competitions is that the client starts arguing like a lawyer in the negotiation round, and the counsel does not talk about any of the legal repercussions of the discussions or the interest of the client. So the client plays the role of counsel and the counsel plays the role of client. So whenever you do that, you get a negative mark on the score sheet. So please keep in mind that what is the role of client? The client is expected to present the facts, to talk about the company they are representing, the venture they are representing, and they need to know the industrial, industrial know-how when they represent a particular industry, a particular company. And they need to discuss it from the client perspective, and any decision which you come through the negotiation, the final word rests with the client and not the counsel, because the client has to take the final call because it's their own entity, it's their own company. So also, and the client should not refer to the legal aspects of the dispute. Otherwise, it looks so fake that the client is also role playing for the counsel. And if we look at the counsel is expected to ensure that the interest of the clients are protected throughout. And the counsel proposes the agenda for the negotiation, which will take discussions forward by addressing their client's interest. And any legal reference so made must be made by counsel only. So there should be a clear-cut division in between the team members, that whose client, whose counsel, and what is client is taking care of and what is counsel is taking care of. And there should not be any miscommunication during the rounds, or there shouldn't be a situation where one person is role playing for the other part, because otherwise it will attract negative points on that. Okay, so the next part is that there are general and confidential information. So I think by now you must have received the general information. So a general information is a summary of the parties and nature of dispute between them, and establishes the position of each party and what they wish to adopt in the negotiation. And the same general information is made available to both parties beforehand, or in certain rounds you just get it like 10 minutes before, depending on the competition. So that's general information which is supplied to both parties. But there is something called confidential information. So confidential information is exclusive to a single party, and the opposing party is not made pricey to this information. And this information describes the client's position and interest in detail, and allowing for the team to think about their plan, their options, approach before entering into the negotiation round. So a confidential information is more like where it is written that by any way your party does not want to settle for anything less than 1 lakh Indian rupees. So that can be a confidential information, but that will not be revealed to another party, to the opposing party. However, it will be known to you that your lowest or your minimum is this, which is provided in the confidential information. So that's the part about before the rounds. And okay, so there is something called BATNA. BATNA is a simple concept. It's best alternative to negotiated agreement. BATNA means that what happens if the negotiation fails. In that particular circumstance, what will be your best alternative? And if the best alternative to this particular dispute, if negotiation fails, is a very good option, is an option which will provide you what you want. In that case, if the negotiation is ending on a note which is not better than your partner, so in that case, you may opt out of negotiation, you may stop negotiation, and you may choose to go for partner. So the idea is that you need to know what will be your best alternative if this negotiation fails. Because if you know what your best alternative is, only then you'll be in a position to assess whether you should accept the offers on the table or whether you should reject the idea, because anyway your partner is having a better remedy than the settlement agreement. So a partner should be thought beforehand itself, and the parties should know what are their partner. So that's the very important part before getting into the negotiation room, that the parties should know what their partner is, and they should be able to assess the offers right there when the opposing party floats the offer. So Batna assists negotiators in assessing options that are most beneficial to your client's interest, as well as options that would be detrimental. And whenever, if the settlement offer on the table is not as good as your partner, it is not advisable to accept it, because at the end, you are having an option which is much better than the offer from the opposing side, because your partner is providing that. So you need to keep in mind about partner before you enter the negotiation. Okay, so let's say that one of the party wants a damage of 100 rupees because of the breach of agreement, and the other party wants 60 rupees, wants to give 60 rupees. So one party requests for a payment of 100 rupees, the other party is willing to give 60 rupees. So, and both the parties are open for negotiation. So in between these two parties, there's 60 and 100, there is a zone of possible agreement. If there is a chance that both the parties can find common ground, and this will enable towards a potential agreement. If there is a chance, there is a likelihood of settlement that both the parties will agree. In that case, it's a zone of possible agreement, because 60 is something which is proposed by one party, 100 is proposed by the other party. So there is a zone of possible agreement in between these two numbers. If one of the party is willing to compromise a bit further and accept the offer from the other side, in that case, you can say that there was a zone of possible agreement and the parties have settled. But one of the party has to go a bit further into their offer. They have to compromise a bit more if they want a settlement. And just to give you an insight on how online negotiation works, so there are certain startups, especially in the West, which are working this way, that you don't need to do an online negotiation. What you need to do is just to open an app and fill in the details, like what will be your minimum, like do you want to give 60 rupees, 70 rupees, 80 rupees, and if you say 60 rupees and the other person says 100 rupees, then there'll be another pop-up that can you go beyond this and you want a settlement. The same applies to the other party. If the parties consents to it, there'll be a settlement. The moment you say okay to 70 and the other party also okays to 70, there'll be a settlement agreement electronically, automatically made. But what if one party says 70 and the other party says 90 and they are not willing to go beyond that? There'll be no settlement. There will be no outcome of this particular negotiation. So there are, startups working on this, that you just need to go by the numbers. But these disputes are not complicated disputes. These are all low value, high frequency disputes where you do not have a lot of complexities involved. However, if you're doing a face-to-face or virtual negotiation where you discuss with the other party, in those cases, it doesn't apply, because in that case, you need to know what will be your number, what will be the other party's number, and you discuss it, you negotiate, and then you move beyond the initial offer. So that's the idea of zone of possible agreement. So please make sure that you assess if we are in the zone of possible agreement with the other party, and in that case you move beyond and you try to settle the dispute. Okay, so we see that in certain competitions we need to provide a negotiation plan beforehand. So what is exactly a negotiation plan? So a negotiation plan is a document that you need to submit before the actual negotiations happen in a competition. So it's the plan which you submit to the organizers. In the real life, you have the negotiation plan with you, so that you know like what's the roadmap to this negotiation. And that contains a case analysis evaluating the respective strategic strong points and weak points of each party. Also, the objectives and goals to be achieved during the negotiation sessions. So in simple words, a negotiation is more like a roadmap to the whole negotiation, where you write everything on a paper, that what will be the batna, what will be the objective, what will be the goal, what are the interests of our client, what are the interests of the other side. Okay. And generally, you are not allowed to change your negotiation plan in competitions once you have submitted to the organizers. So whenever you make the negotiation plan, you make sure that the approaches in these plans are well thought out and allow for enough flexibility to count for all possible situations and end agreements. So you will not be allowed to change your negotiation plan. So please keep in mind that it shouldn't be so stringent that it will not account for something which may happen in the negotiation, which will go against something which you have written. Okay, so it should be flexible enough. And whenever you write it, you need to, think a lot, because negotiation plan also plays an important role in your score sheet. So in some competitions, you have a negotiation plan to be submitted beforehand, and you get certain marks which will be added in your preliminary rounds, and then you will be, there will be a list of people who will be going for the next round. So in those cases, it's very important. So please pay attention to this if you have to submit a negotiation plan. And the competition formats are generally that you participate as a team in two prelim rounds. Generally, it's two preliminary rounds. And after that, there are subsequent knockout rounds and then the finals. So it actually depends on different competitions. Like there are some competitions where you have like more than 2 or 3 knockout rounds. So it depends on the competition. But the 2 preliminary rounds are basic, where you have to qualify for the next round. And after preliminary, all the rounds go like on a knockout basis. Okay. And the next part is that there are certain competitions in which the teams are required to switch the roles of the client and the counsel in between the two students. So again, it depends on different competitions. And here comes the most important part. Timekeeping is very important. And adherence to the time limit is the most important thing, which will be taken note by the judges. So whenever you have been allotted a time, please follow that. A lot of teams, when they keep on negotiating even after the time limit is over, they do not stop, they go over and over the time, which will actually attract a lot of penalty, a lot of negative marks. So whenever you have a time provided, please finish before that. And there shouldn't be any excuse for taking a lot of time, and you shouldn't be saying after the rounds that we took a lot of time because of this, or we were about to reach a settlement. Whatever time has been allotted, just finish your negotiation, wrap up the round within that time limit. That's very important. Okay, so let's look into the negotiation further. So when you enter the negotiation rounds, the first thing which you need to do is an opening statement. And that's your first impression, and it matters a lot. So in the opening statement, both the parties will be given an opportunity to introduce themselves, to introduce the facts, to highlight the dispute, what's their position, what's their expectation from the process. And a strong opening statement generates momentum in your favor and allows for the opposing party to understand and work with you better. So an opening statement is very important, because unless until you are able to showcase that you know about the dispute, you know about the interest of your party, the other party, and what's your expectation from this process, that's very important. And that's actually where you have to start strong, so that you get into the minds of the judges. So that's the first part. And then it's about setting of agenda. So any party can initiate the agenda for the negotiation. So, however, it's always better to be the first side setting the agenda, and the opposing party may either choose to accept this agenda or propose modifications to suit their interests and objectives. And a lot of time shouldn't be taken, a lot of discussion shouldn't happen on setting of agenda. You should move to the next part where you actually start negotiating. And care is to be taken by the party setting the agenda, as they are to keep in mind the issues that their client treats on a priority basis and accordingly place them in the order of discussion. So whenever you talk about the agenda, you need to make sure that the things which your client wants to put on priority should come first. It shouldn't be the case that the issue which is not even important is first, and the issue which is very important comes fifth in the agenda. So please keep in mind that it should be in the priority basis. The first one should be the most important issue which needs to be discussed and negotiated. Okay, so let's look at the negotiation process. So in negotiation, you see parties making offers and counter offers based on your negotiation plan. However, we see that a lot of students in the negotiation competition, when they make offers, there are some cases where they just make offers based on numbers without supporting with any reasoning, like why are they offering this? What's the reasoning that they're coming up with this offer? So whenever you make an offer, you need to associate a reason for that, a support for that. You can't just say that I'm willing to settle for 60 and somebody says, no, I'm willing to settle for 100. You can't just go with the numbers. It's not like, the number based negotiation in an app. It's not that. It's face-to-face negotiation. And whenever you say that I'm willing to, give you a certain amount of money, and you give a reason why that particular amount, why not more than that? Why are you not compromising? And for that, you need to use your facts. If there is a breach done by the other party, you highlight that. If there is a loss to your own party, you say that we have already suffered a loss. So the reasons are very important. And then paying close attention to the opposition, to the position adopted by the opposing party. It's very important that you understand what is the position of the other party. And then you tailor your proposals better to their interests. Okay. And let's say that if there is anything which you do not understand clearly, please feel free to ask questions. And asking question to better understand the details of the confidential information will help you a lot to make a very good offer that the other party will be willing to accept. And whenever you think about the options, the solutions, try to be creative and try to find out something which will be mutually beneficial for both the parties. If there is something which you can find out, which will be beneficial for both the parties, then it will be great. And in those cases, you of course get a bonus point for coming up with a creative solution. Okay, so criteria for judging. So there is, of course, one thing negotiation plan comprehensiveness. If that's a part of the competition, then opening statement plays a bigger role, and teamwork. So it's very important that whenever you go into any competition, if you're in the competition as a team, you have to behave, you have to work with your team members. So I see in a lot of competitions, these students are more interested in their individual participation and not the teamwork. So whenever you participate in negotiation, you have to make sure that the client and counsel are a team. So when the client is discussing something and a question comes up with relating to law, the client should refer to their counsel asking like, Mr. blah 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 or Miss blah blah blah, what do you think about this? Does that suit my interest? What do you say about this? And the similar thing happens with the council. Let's say if the council is discussing in the negotiation round and there is a question there is a proposal made by the opposing party. So the council shouldn't be saying yes or no. The council should refer to the client and ask that this is my opinion. What do you think about this proposal of blah, blah, blah. So in those cases, it's very important that the teamwork is exhibited and you get points for that. There are a lot of competitions which have a specific criterion of teamwork. And then comes building relations with the opposing party. That's very important. You shouldn't start fighting with your opposing party. You should be very cordial. You should showcase that you're very professional. You give an opportunity to speak them. You shouldn't be cutting them off. And that actually counts for your scores. And generating creative solutions is something which we have already covered. Analysis of interest, the reasonings. What is your interest? Why do you think so? Relating it to facts. That's also important. Okay. And the last point is that a lot of students think that it's always necessary to come up with a settlement at the end of the negotiation rounds. Otherwise, we get a penalty marks. There is nothing like that. If you can reach a settlement during the negotiation session, it's good. If not, it's totally fine. But please understand, the most important part of the negotiation session is that the quality and level of engagement exhibited through the process, strategies adopted, and the flexibility of the team's approach to the negotiation. That is something which is important for the judges. It's not that if you reach a solution, if you reach a settlement at the end without having a good opening statement, without having a good teamwork, without respecting your opposing party, in that case, they'll be giving you higher 90s. There is no way out that you get higher 90s in that situation. So please keep in mind that it's the process which is more important. It's not only the settlement which needs to be there. Okay. Okay, so now we come to the last part where there are certain tips which I need to share, and after that we'll be open for questions if you have any. So planning is foundational to a productive negotiation session. So please understand that the objectives you're trying to achieve is important. And in assessing said objectives, it is pertinent to understand the relative importance of each of these objectives, thereby allowing for the negotiator to prioritize what is most important for their clients and get the possible negotiation settlement. You need to know how much of one thing you are willing to give up in exchange for the other. You shouldn't be taking a lot of time when you are in the negotiation session thinking about, should I give it up? Should I take it? Or what should I do? You should know beforehand. You should be, your team should be well prepared that, the moment you have something on the table, you have a very good reply to that no, we are not going to settle for this because of blah, blah, blah reasons. And we are going to settle for this, or if we can go a bit further, there may be a chance that we will settle, but not this. So you need to be very sure with what is more important to you. Do you want to leave the table, or do you want to go ahead and compromise something and find a settlement? And then it's important to get into the mind of the opposite party as well and understand why they are at the negotiation table. What is their interest? What are their objectives? And then identify common objectives, which will play an important role in creating a common ground where both the parties can come together and find a mutual solution, a settlement. So you need to think also from the perspective of the opposite party, that what will be their interest, what are their goals, what are their objectives. Only in that case you'll be better equipped to create a solution which will be acceptable to both the parties. Okay, so client interest over negotiation position. So whenever you are in the process, it is important to keep an open mind and ensure that your strategy remains as flexible as possible to account for opposing interests in accordance with the interests and goals of your client. You shouldn't be very adamant, static with the position in the negotiation. An easy proposition can serve to do more harm than benefit to your client. So you shouldn't be having static, style of negotiation. You should be flexible enough to give room, to give a space so that the opposing side can also share what they think, what is their interest. So instead of position, you should focus on the client's interest, that how are we better how we can, in a better way, we can find a solution. And flexibility in the approach allows for creative solutions to be drawn up, which are favorably looked upon by judges. And you get a special point for that. So whenever you are in the negotiation, please do not adopt a static position. Please be flexible. Don't be like, I want everything. I want 100%, whatever has been written in my general information, I want all of that. Please look into your confidential information till what point you are able to compromise, and then you do your own analysis, and then you have a strategy through which you can reach the maximum benefit from the negotiation. Okay, so dealing with uncooperative opponents. So it's always two parties required to clap. So refrain from reacting to provocation from hostile negotiators. And in those situations, acknowledge that the opposing party has the right to feel this way and try and steer the conversation back to the shared interest in the negotiation. Remind the hostile party that they are at the table to work through their problems together and arrive at a mutually beneficial proposition. You should make an attempt to diffuse the situation as much as possible. You shouldn't be taking part in that discussion to aggravate that. And you should keep in mind that the larger interests and goals of your clients is to settle the matter. That's the reason why you wanted to come to the table for negotiation. And in no case should a negotiator counsel engage in an argument with the opposing side, regardless of the stalemate they find themselves in. So you shouldn't be arguing anything apart from negotiating the dispute. Even if the other party is doing that, you should try to, bring back the conversation towards the shared interest of negotiation and try to find a way out so that the parties come back to the agenda which you have already decided in the beginning of the negotiation. Okay, so that's the basics of negotiation which I wanted to share with you. Now we are open for question if you have any.
Participants can use the chat box to ask questions to sir. So it was indeed an enlightening session.
Thank you.
So someone has privately messaged me, can BATNA be used? Is litigation an option for BATNA? Yeah.
I will say that no, litigation is not a better option unless until you are of the opinion that through litigation you are going to get a better outcome, which is, if you compare that from the, the, if you are able to think that litigation will give you a better remedy, in that case, yes, but it's very impractical. I don't think it will work in the real life, because if you go for litigation, unless until you're a big company fighting against a very small company and you have a lot of resources, and you think that if you go to litigation you can threaten the company and then the parties will come back to you for a settlement, which will be way much better than this negotiation, in that case maybe yes, but not generally.
So there is another question. The session was very comprehensive. Thank you. Just wanted to understand how we identify BATNA. We have to figure out using the info given in CL and CI and GI, that is the confidential information and general information.
Yes, so it's all, subjective to your CI and GI. So whenever you have that, you need to find out that exactly what are the other alternatives, and somewhere in your GI, somewhere in your confidential information, it will be it will be, hiding out right there in your CI. So when you read it again and again and you think it from the perspective that, let's say that this negotiation fails, what will this party be doing? And somewhere from the CI and GI, you'll be able to figure out that maybe the parties will go for this. It will be provided in the CI and GI. It's not like you just, make it up. You have to read the problem. You have to read the CI, GI as it is provided by the organizers. But if you find a clue, if there is a clue, then you'll be, in a very good position to find out what your BATNA is.
So the next question is, can you kindly define the term creative in coming up with creative solutions with an example?
Okay, so let's say that there is a very simple dispute in between, let's say, a chicken farm and a stadium right next to it. So the chicken farm is complaining that, your cricket ball comes out of this stadium, you have a lot of noise, you have a lot of light pollution coming out from the stadium, and therefore it affects this chicken farm. And therefore they have this dispute. So they want to have a negotiation. So in that case, what will be the solution? One of the solutions which the chicken farm asks is that, you relocate the stadium, okay, or you stop all of this nuisance. So the stadium is saying that, why don't you shift? Why don't you move somewhere else? So there are a lot of, solutions to this, but it's all about whether there'll be a common solution for that or not. A creative solution can be more like where, so let's say if the confidential information provides that, the chicken farm is willing to relocate, if they are sponsored, if they are funded, okay. The another confidential information is, let's say if the stadium gives an exclusive right or gives something to the chicken farm financially, or some orders monthly, annually, then they will think about this. So let's say the creative solution can be that there is an exclusive agreement in between the stadium and the chicken farm with respect to the sale of, chicken products. Or another solution can be like, they sponsor them and they relocate, they expand. So there can be a lot of creative solutions, and it depends on each case to case basis. So if you can find out some way that both the parties get something, it's not like both will get 100% and 100%. So it depends on the CI and GI whether there is a room for a creative solution. Not in a lot of cases you can, it's not like in all the cases you'll be able to do creative solution, because if that's the case, why people have to compromise? So, but there are certain room for creative solutions, and if you are able to, come up with one, then you get points for that.
Next question is, sir, does putting out better offers on the negotiation table get a party more scores by the judges compared to the other side?
Can you please repeat the question?
Yes, sir. Does putting out better offers on the negotiation table get a party more scores by the judges compared to the other side?
I'll say, like, floating offers is a good thing, but you shouldn't overdo it. Like, of course you get points for that, but whenever you float an offer, you need to provide a reasoning for that. Like, why are you giving this offer, or why are you giving offer till this number? So you provide a reason for that, and of course you get points for that, but it shouldn't be like, if it is unwarranted, there is no reason supported by, in that case of course you'll get a negative marking because of the overdoing or floating proposals again and again, which is not being accepted by the other party. So please keep in mind that whenever you float an offer, it's a well thought offer, there is a reason for that, and you state the offer and you state the reasoning that we are willing to do this because of this, because of 1 2 3 reasons, because of the breach, because of the damage, because of 3 or the other reasons. In that case, the other party has to answer because they are in the negotiation session. It's not like you're writing an email, the other party will take time. In those cases, you get a lot of points because then you have an offer with a lot of reasonings, and the other party, if they reply back with a similar level of reasoning, of course the other party will also get a lot of marks. If let's say they are baffled by this offer, there may be a high likelihood that they lose out points, and the party which floated the offer which will get points.
This brings us to our last question, which is how to establish cooperation between counsel and client.
Okay, so it's very simple. Like whenever you discuss, whenever you negotiate, you give due consideration to the views of the other member. So let's say, like I have already given you an example, that let's say there is a proposal which is coming up, or there is something like a deadlock in between the parties. So you may ask, and let's say you don't know the answer for a specific question coming out from the opposite side. So you ask your counsel or the client that you tell the answer in like 1 line, 2 line, and then you say, I would like to refer to my client, or I would like to refer to my counsel, and I think my counsel will be in a better position to talk about this. So let's say if the counsel is talking about the dispute and somebody asks a specific question in between, that why this company is like this, in that case it's always better the client should speak up. But if the client speaks in when the counsel is already taking the lead, it doesn't look good. So the counsel should actually refer this to the client, that I would like my client to answer this question. And things like this will give you a very good outlook that you have a very good cooperation in between the counsel and client.
I think that's it. One more question, sir. This will be the last question, participants. Is it affordable in a negotiation competition to stir off from the actual facts and twist them to suit our team's needs? This is something usually done in moot courts. So to what extent is that allowed in a negotiation competition?
Okay, I'm really sorry, but I'm not saying this is not done in moot courts. What I'm saying is this is not advisable to do in any moot court competitions or any competitions, even this negotiation competition. If you look at any of the rules, let's say this Nyaya Shastram has a rule. It already has a rule. Let's say it does not write that you need to read the problem, the confidential information, the general information as it is. Even if it doesn't say that, it is implied in all the fact sheet, in all the informations which has been provided by the organizers. Doesn't matter, it's a moot court, negotiation, mediation, competition. You have to read it as it is. Okay, there may be a chance that if there is an implied thing coming out from the facts, that is something which you may talk about, but there is nothing like you create your own facts. Let's say that it is not written in the dispute that the chicken farm is suffering from this they are having huge losses because of COVID-19 and all of that. Let's say it says that, it doesn't mean that you can start a new argument that it's their only way to earn money. They are very poor, they do not have money to run the business. Like, you cannot make it up. You can say that they are running in losses. That's of course true according to the facts, but you can't make it up to a different level that everything, like it's their right to life. This chicken farm, if the stadium is not stopped from creating this nuisance, the right to life will be affected. That will be a very large extension of this argument. So I would suggest that you should refrain from doing this, especially in moods. Like in moods, don't do it, because there is no room for that. Maybe in certain negotiation and mediation where it says about the parent argument is already provided, then in some cases you may have a chance to look into the subsidiary argument, which is more like an implied fact coming out from this. But you shouldn't be focusing on that, because let's say that if you do all this, you have a fact which is not even provided in the facts, but you say that this is implied, that's why I have argued, or you showcase that. Let's say the other party, the opposite party, is so smart and they cut you off right there and they say that, I'm really sorry, but we had an initial meeting, we discussed about this, but this is not something which we are aware of. And in that case, of course, the judges will take a note of that, that this is beyond the information provided by the organizers for this competition. So you can't just make your own facts in favor of your side. Otherwise, if somebody catches you, unless until nobody catches you, it's very good for you. But in majority of the cases, people will take a note of it.
Thank you, sir, for taking time out of your busy schedule and joining us today. This brings us to the end of the first segment of the orientation session. Now, I would like to call upon Ms. Saundarya Rathod, research scholar, Ericsson, to brief the participants about the new initiative with Hypotheticon Educational Academy called IPTSE, the Intellectual Property Talent Search Examination. Over to you, Saundarya.
Thank you so much, Arav. Am I audible?
Yeah, you are.
Good afternoon, everybody. Thank you so much, Arav, for this lovely introduction. Thank you so much, Akash, sir. That was actually a very informative session. And I genuinely think that this will help all the participants a lot. I would like to introduce IPTSC to all the participants. Along with Ericsson, we are acting as associate partners in this initiative, and we are delighted to collaborate with Nyaya Shastram for the second edition of RK Ratan Singh, negotiation competition. So to start with introducing IPTSC Academy. IPTSC Academy is a startup and it's an initiative by Hypotheticon Private Limited. And Hypotheticon is an educational academy which focuses on the knowledge sharing and education about intellectual property. It is intensively involved in sensitizing various sections of students and entrepreneurs about the education of intellectual property in economic growth. And to achieve this, we collaborate with a lot of government and private institutes and educational blogs such as Nyaya Shastram, and we try to propagate this knowledge across educational institutes, including schools and universities. So I would like to start with the introduction about how we came about and what have we achieved till now. IPTSC has been awarded by the World Intellectual Property Forum, and we are delighted to have been awarded by Shri Suresh Prabhu, who was one of the cabinet ministers in the Indian government. And we have received a lot of other recognitions as well. IPTSC, with the help of IPTSC Academy, administers several IP educational programs under its venture. IPTSC is one of its flagship program. The main objective is to administer the and first of its kind Olympiad style exam, especially for increasing the knowledge of intellectual property. And it also assists us in spreading various courses about IP and its economic benefits across across industries and universities. It also includes increasing the rankings according to NAIF and other NAC accreditations that are taken out by the UGC and other educational bodies. Uh, we are supported by MSMEs, startups, and other industrial associations, along with different branches of the government. And IPTSC's fourth edition is coming up. We have successfully organized 3 editions. I myself was a beneficiary of the third edition, and that is why I am associated with this startup, because I realized how important is it for young students and entrepreneurs to have this opportunity. So we it launched in 2018, and it tests the knowledge of individuals on patents, design, copyright, GIs, designs, and trade secret. It is supported by several organizations, one of which is Ericsson, who is the other associate partner in this event, ASOCHAM, Creative First, and several government bodies such as the Ministry of Science and Technology, Ministry of Information and Communication, Gujarat government, Punjab government, and we have recently got the support of Andhra Pradesh universities. We sign a lot of MOUs with various educational institutes so that we can propagate IP education with the help of webinars, talks, and discussions with the students in those organizations. The exam is especially for students of schools and universities, and it's different and customized for their respective streams, which includes law, engineering, architecture, sciences, design, fashion designing, and media students. It also certifies the students' abilities according to rankings in the examination. Uh, so as I have already said, that it's organized for school students, university students, and since in the fourth edition, we will include faculties, working professional, and startups as the participants. And this event is particularly organized for the negotiation competition. Competition is particularly organized for law students, but the exam is also organized for designing, engineering, and other fields of education as well. The exam is for 60 minutes for college students, and there is 60 minutes for 60 questions. There is usually no negative marking. And to qualify, the candidate must score 40% or above. At university level, the national rank holder has to achieve two criteria. The first is it has to achieve highest score, and the second is that they should take lesser amount of time compared to their other candidates. Lesser amount of time is also considered to be a tiebreaker. And for regional rank holders to be declared, there should be at least 500 students from that region. The top 20 rank holders are felicitated, and the selection is based on the accuracy of their answers and the time taken to complete the exam. The process of examination starts from a registration. It will start from August for the fourth edition, and it's usually done by a user-friendly interface run by IPTSC Academy, wherein the participants can register and they can access course material, which is prepared by research scholars such as myself and the entire team. They prepare course materials, and this is offered to all the participants for preparation of this IPTSC exam. The course material is made usually under the supervision of Dr. Sheetal Chopra. She is the director of IPR policy in Ericsson India, and Ericsson is a very strong supporter of IPTSC. And then after the registration, the registrants, candidates are given a opportunity to take a mock test where they get 1 month's time to prepare and understand the criteria and the type of exam. This is followed by a final exam where the candidates will be given a period of 15 days to participate it's a very flexible form of exam, and we try to create all opportunities so that students do not students do not lose the opportunity to participate in this exam merely because of lack of time. We understand that students such as yourself are busy with a lot of college activities, so college or school activities. So there is a 15-day period where you can give the exam at any point of time. The I have already gone through the methodology, and the score obtained in the examination is very transparent. You will be guided at every point of the examination. The winner will be selected from top 50 rank holders and who will be interviewed by the jury. Uh, these activities also give a lot of other opportunities for students to move forward in the field of IP. And there are a lot of other benefits that we provide to participants. Winners receive prizes and scholarships, and along with internship opportunities, certificates and trophies are provided to the winners and to meritorious participants. We have also launched an initiative which is called Learn and Earn, whereby IP enthusiasts can make YouTube videos, and the YouTube videos will be posted on the official IPTSC channel, where a YouTube teacher or a youth leader will be promoting IP awareness on different topics, and they will be earning according to the criteria that we have for our YouTube channel. And along with that, the research team also gives out a lot of webinars and course materials under the supervision of IP experts for the promotion of IP knowledge. So the third edition of IPTSC and IP Conclave was virtually organized on April 28, 2021, and many eminent speakers were present on the occasion. The chief guest was Professor Sahasrabudhe, who is the chairperson of All India Council of Technical Education. And as I've already said, that we are supported by a lot of government initiatives and government departments. So a lot of the guests were scholars, academicians in the field of IP, industry experts, etc. And we also hosted the Manak Inspire government initiative, Ministry of Micro, Small and Medium Enterprise, Punjab State Council for Science and Technology, and Ministry of Science and Technology. Uh, the first and the second edition was graced by Sri Suresh Prabhu, and the third edition was graced by Anil Sahasrabudhe. The participants and the beneficiaries were had the opportunity to interact with the guest of honor and other guests. And along with all these initiatives, IPTSC does have its own YouTube channel where the participants get to interact with senior IP officials and industrial experts. We organize regular webinars and weekly videos on interesting IP topics. And IPTSC Academy provides certificates for every webinar they host. And some lucky subscribers have the opportunity to win exciting gift vouchers for better interaction and uh, opportunities. So this initiative is mainly for promoting IP education from any way possible to future students, future lawyers, future entrepreneurs. And we think Nyaya Shastram is a great platform, and the negotiation competition is going to be a very great platform to explore another area of IP laws, that is negotiation. A lot of negotiations happen through a lawyer, and it's a very regular part of IP administration. And we aim to provide this knowledge to the participants as well. So if you have any question about IPTSC or are functioning in general, please feel free to reach out to IPTHCon or IPTSC. I'll be happy to take up questions right now as well. Thank you.
Participants, if you have any questions, you can use the chat box feature to ask questions. I have received a question on private chat. What is your experience with IPTSC and the benefits you received?
Thank you for that question. I participated in the third edition of IPTSC last year, and I was ranked second in the national college level criteria. And right now, as I've told you, Ericsson is one of the main partners, and I am interning with Ericsson under Dr. Sheetal Chopra. She's the IPR policy head for Ericsson India, and I am interning under her. I have received a lot of opportunities to network with other uh, policy heads in different industrials such as HUL, Creative First, and I have had the personal opportunity to host a lot of government officials, such as Professor Unnat from JNU or BK Sahu, who is one of the who is one of the pioneer right now in IP development for India in terms of government officials. And right now, I'm also working as the research scholar, and I'm a core committee member for this startup. This is a startup, we are personally very responsible, and we personally participate in the development of the startup. And I am responsible right now for organizing events for IPTSC. I also create research material. And right now, as I've told you, we have signed a lot of MOUs. So we deliver webinars for other universities. And as I am working directly under an industry expert, I get to interact with her. People from her background, and I get personal feedback from them. I get to work in a startup environment as well. So I think in terms of knowledge sharing, in terms of technology transfer, in terms of development of a startup, I am getting all these experiences in one go. So I would say that it's a very beneficial journey for me.
Another question is, participant, this will be the last question that we'll be taking up today. How does IPTSC help in internships and placements?
So, as I said, I am interning in Ericsson. Other participants have also got the opportunity to personally interact with uh, other jury members or other guests of honor. And when it comes to networking, we try to network. We have the personal opportunity to talk to them, so we can, I personally approached Dr. Sheetal Chopra if I can intern, and she chose me to intern with her. And this is how they help. They help in internships. They right now do not help in placements, but they help in CV building. They help in networking. So ultimately, this will help in your placements, but directly they do not give placement opportunities. Internship opportunities are plentiful, and if you participate, if you score well, or if you are one of the primary rank holders, then you get the opportunity to intern with a pioneer in their own field. So, yeah.
Thank you,
Thank
Saundarya.
you.
It was indeed a wonderful session. We
Thank you
hope
so
that
much.
all
All
the
the best to everybody. And I wish all the participants and the team of Nyay Shastram the best of luck for their upcoming event.
Thank you, Saundarya. We hope that all the IP enthusiasts here have taken a note of the same and are ready to join you for IPTSC. With that, we come to the end of this orientation session today. Once again, thank you everyone who have joined us today through Zoom and via YouTube Live. all the best participants.